Yes. Okay. So we will be having the session for Code of Civil Procedure today. So very good afternoon to everyone, and we will be having the session on CPC today. That is the rapid revision round for Code of Civil Procedure. As all of you, those who are now attempting the Madhya Pradesh judiciary exam. So it is very important for you people to understand that okay, in the MP judiciary, what kind of questions are coming in the exam with respect to the CPC, and apart from that, a lot of things are there with respect to the Code of Civil Procedure, which we will be discussing in the today's session as well as in the session for tomorrow. And this session will be lasting more than 2 hours. So first of all, I will be doing the sections area today, like which sections are important, what kind of questions can be there from the sections area. And by the tomorrow session, we will be shifting to the orders area, like which orders and which kind of provisions we have to see with respect to the Code of Civil Procedure. So let us start with the session. Okay. So let us begin with the session. Look, as far as the CPC is concerned, there are two kind of things which we people have to understand, like what kind of questions can be there, what kind of questions can be there, and the most important factor which you all have to understand is that it is not only that the questions with respect to the bare act only will be there, the questions might be from some conceptual areas also. So I will be taking up the things one by one. So first of all, let's have some basic things to understand, like with respect to the CPC. Now, what those basic things I'm talking about? Just have some dates in your mind, like when the CPC was got the assent. So it was 21st of March, 1908, the date on which the assent was given to the CPC by the British Legislative Council. And apart from that, on which particular date it came into force, it is 1st of January 1909. It is the date of enforcement. Date of enforcement. After this, the main important points which people have to see, and I request you all people that please have your notebooks with you, so that if any point you had missed while your preparation, so you might jot it down. The next thing is, like, there were major three amendments in the CPC. The first amendment, which was an important amendment, it was in the year 1976, which came into force on which came into force on 1st of February 1977. This is again a date which is important. Then another two amendments are of 1999 and of the year 2002. These two amendments, these two amendments came in force on 1st of July 2002. So these dates should be in your mind, you know? Like the amendment of 1999 and 2002 when they came into existence. So it was 1st of July 2002. Like the next thing which you people have to understand is that who recommended these amendments. So it was Justice Malimat Committee. Justice Malimat Committee has recommended certain amendments which were incorporated in the CPC in the year 1999 and in the year 2002, and thereby we got this particular amendment. Another thing which people have to consider, like these amendments of 1999 and of the year 2002 were challenged in which case in the Honorable Supreme Court. So it was. I hope I'm clearly audible to all of you. Yes. So the case in which the amendments of case in which the amendments of 1999 and 2002 were challenged in the Honorable Supreme Court, were challenged in the Supreme Court. That case is Salem Advocates, Salem Advocates, Bar Association, Tamil Nadu, Bar Association, Tamil Nadu versus Union of India. It was of the year 2005 Supreme Court, and it was delivered by Justice Y.K. Sabarwan. Justice Y.K. Sabarwan. So these are the basic key factors before going to the operative area of the CPC. You people must have to see, like many of the candidates have joined a bit later. So the point is, like assent is given on 21st of March 1908, date of enforcement 1st of January 1909. Amendment was in the year 1976, the major amendment. It came into force on 1st of February 1977. Another two amendments, that is of 1999 and of the year 2002. These two amendments were there in force from 1st of July 2002. The amendments of 1999 and of the 2002 were on the recommendations of Justice Malimat Committee. This amendment of the 1999 and of the 2002 was challenged in the Honorable Supreme Court in the Salem Advocates Bar Association Tamil Nadu versus Union of India, whereby the Honorable Supreme Court has stated that these amendments are constitutionally valid. Now, how many sections and chapters CPC is having? Like such kind of questions can be there in the multiple choice question. So in CPC we are having 158 sections, 158 sections, and we are having 58 orders. It is 151 orders. It is 158 sections and 51 orders we are having in this particular law. So let us proceed to the basic things with respect to the Bail Act now. Let us proceed. Like the main important definition area which people have to see is like the definition of the word decree. Like in many states, such kind of questions are being asked, like what is decree or what is deemed decree, or there are certain other things which are important, and you must have to be aware of that. So as you people can see, decree means what? Decree is defined in section number 2, clause 2, and which is stating that any formal expression of an adjudication which conclusively determines the rights of the parties, and whereby the controversy in a particular suit is going to be decided either preliminary or it can be final. So decree can be preliminary, decree can be final, or it can be partly preliminary or partly final. So you people please tell in the comment box that in which area of CPC the preliminary decrees can be there. In which area of CPC preliminary decrees can be there. Along with that, there are certain decrees which are considered to be the deemed decree, and in order to, section 2, subsection 2 itself, it is stating that any adjudication from which an appeal lies as an appeal from an order. So if any order is being passed by the court, then that order will be considered to be a decree. Then that order will be considered to be generally an order. But the point is that if that order falls under these two categories, like if the order falls under the category of rejection of claim, that is order 7, rule 11, or if the order falls under the category of section 144, that is the concept of restitution, then those orders will be considered to be the deemed decrees. But apart from these two orders, other orders will only be the orders, they will not be called to be the decrees. So this is the first basic thing, like what are the decrees and what will not be called to be the decrees. So it shall not include any order from which an appeal lies from an order. So any appealable order will not to be called as a decree, rather it will only be an order, and section number 2, clause number 14 is specifying that. The next thing is any order of the dismissal for default of a particular case, that order will also be called to be an order only, it will not to be called as a decree. So how to make a difference here? Like decree means any decision of the court which conclusively determines the rights of the parties. Decree can be preliminary, decree can be a final decree, or decree can be partly preliminary and partly final. Partly preliminary and partly final. But there is a concept of a deemed decree. So where the deemed decrees we are getting, in which provisions, you please tell me in the comment box or in the chat box. Where are the provisions of the deemed decree in the CPC? जल्दी से बताएंगे सभी लोग. Where is the provision of deemed decree in the CPC? So number one is Order 7, Rule 11. If any order with respect to the rejection of plaint is being passed by the concerned court, that order will be considered to be a deemed decree. The next one is section number 144, that is an order with respect to the restitution. That order will also to be called as a deemed decree. But apart from this, we are having some other provisions also which people have to take care, like order number 21, rule number 58, order 21, rule number 98, and order 21, rule number 100. These provisions are also having the concept of the deemed decrees. So please mark it down. These provisions will also be having the concept of deemed decrees. So if any question comes from this particular area, you must be able to understand that what actually the deemed decrees are and what will not be included in the decree. So we can write that decree does not include number one, that is appealable orders. Appealable orders cannot be called to be the decree apart from the things which are mentioned above, and any order of dismissal in default. Any order of dismissal in default. So these kind of orders are generally the orders, but they will not take place of the decree. So these are the first basic things which you people have to understand. Now coming to the next area of discussion, that is under which provision we are getting the concept of preliminary decrees, because many times in the MCQ such kind of question comes where the preliminary decree is there in CPC. So preliminary decrees find its position under Order 20, Rule 12, 13, 14, 15, 16, 17. Sorry, it is 16 and thereafter it is rule number 18. So in these rules, we are having the certain kind of cases whereby the court can pass the preliminary decree, and once the preliminary decree is passed, and thereby after doing the further calculations or further things, the court is going to pass the final decree. So in rule number 12, we are having the cases of recovery of the property as well as the many profits. In rule number 13, we are having the concept of administration suits. Administration suits. In rule number 14, we are having the concept of preemption. Preemption. In rule number 15, it is the dissolution of the partnership. Partnership. In rule number 16, we are having the disputes with respect to the principal and the agent. Principal and agent. And in rule number 18, we are having the concept with respect to the partition and separate possession. Partition and separate possession. So, if any order is being passed under, if any decree is being passed under these particular orders of CPC, then that decree may be a preliminary decree, and once the preliminary decree is passed, thereby the court may pass the final decree between the parties. So, you people have to take care of this thing. Now, what other definitions are important for you people? That is the definition of a foreign court and a foreign judgment. Directly, they might be asking you under which provision this definition is given. So, foreign court is a court situated outside India or which is not established or continued under the authority of the central government. So, that court will be called to be the foreign court. Foreign judgment means any judgment which is being passed by the foreign court. The next definition, which is important for you people, will be section 2, clause number 9. Like, what is a judgment? So judgment means a statement given by a judge of the grounds of decree or order. So this definition is also important. Another definition which is important is who is a legal representative. So with respect to the legal representative, he is a person who represents the estate of the deceased. A person who represents the estate of the deceased, and it includes all the persons who intermeddles with the estate of the deceased, and where a party to a suit, where a party sue or sues in a representative character on whom the estate devolves on the death of the party who is suing or sued. So legal representative generally, if a question comes, you must have to understand that he is a person who represents the estate of the deceased in the court. Another important definition for you people, that will be the many profits. Like what actually the many profit is. So if a person is there in a wrongful possession over the property and that person knows that he is in a wrongful possession, but but by holding that possession, that person enjoys certain profits. While holding that possession, the person enjoys certain profits which he is not entitled to enjoy, or which he is not entitled to enjoy, but still he is enjoying. So, whenever a person, whosoever is the having the right entitlement over the property, that person files a suit for the recovery of the property, as well as the person claiming the many profits also. Then many profits are those profits which a person who is in wrongful possession had actually received or might have received with the ordinary diligence therefrom, because he is holding the property in a wrongful position, and whatever the profits he is generating from that, that profit will be called to be the many profits or the profit which he might have received. So everything can be claimed by the person who is holding the title over the property. The next definition is of movable property. So movable property include growing crops, though this definition is not completely exhaustive in the CPC. In the TPA, we are having some more exhaustive definitions with respect to the movable property. But yes, okay, if the question comes with respect to the CPC, so you have to take care of the point that okay, movable property includes growing crops. Thereafter, the another definition which is important, that is a public officer. Generally, they used to ask that under which provision of CPC the public officer is being defined. You must be knowing that it is section number 2, clause number 17. Now, along with this, as all the area with respect to the definition which I told you people, that is important. And the main important definition which can be there in your exam, specifically with the prelims exam of the Madhya Pradesh, that is, uh, if a decree is passed, then what are the types of decree? So we must be able to understand that what kind of decrees can be there. It can be preliminary, it can be final decree, or it can be partly preliminary or partly final. Then another question comes like, okay, where the preliminary decrees can be passed. So it can be under Order 20, Rule number 12, 13, 14, 15, 16, and 18. Rule number 17 is not there. इसका ध्यान रखना है. Rule number 17 is not there. Along with this, there is a concept in Order number 34 also. Order number 34 of CPC also, which is dealing with the same kind of a thing. Like whenever the suit is with respect to the mortgage, whenever suit is with respect to the mortgage, so of a mortgage, there are generally three outcomes. One is the foreclosure, another one is the redemption, foreclosure, sale, and redemption. Three outcomes are there: foreclosure, sale, and redemption of the property. So foreclosure के cases में, in the case of foreclosure also, the court has the liberty to pass the preliminary decree. So Order 34, rule number Rule number 2 and 3 will take care of foreclosure. Rule number 4 and 5 will take care of sale. And rule number 7 and 8 will take care of the redemption. But there also, the court has the liberty to pass the preliminary decree. So if any question comes with respect to this particular point, you must be able to understand that, okay, it is talking about either order number 34 or it might be talking about order number 20. Okay, now coming to the next area of discussion, you people just have to see section number 3, that what are the subordination of the courts. So for the purpose of the CPC only, the district court is subordinate to the high court, and every civil court to the grade inferior to the district court, and every court of small causes is subordinate to the high court and to the district court. So high court is the superior court. After that, it will be the district court, and below the district court, there will be the other civil courts, and the court of small causes is also subordinate to the district court. So this is the basic hierarchy of the courts that is given in section number 3. After that, section number 5, that wherever the the revenue related matter is there, it will be dealt by the revenue courts. The civil courts are not going to take up the matters of the revenue courts. It is the express bar over the civil courts. Section number 6, that no court will be having the jurisdiction to entertain the case beyond its original jurisdiction, beyond its pecuniary limits. So in every state, we are having the different pecuniary limits, and we have to take care like what is the pecuniary limit as per the courts act of the concerned law. So section number 6 is talking about that. The next main important point which people have to see, that is section number 9 onwards, because section 9 is again a very, very important section. I will be telling you people a lot of cases also with respect to section number 9. Look, the main point is that if someone says that okay, do the civil courts are having the inherent jurisdiction to entertain the matter, the answer is yes, civil courts are having the inherent jurisdiction to entertain the matter. Civil courts have inherent jurisdiction. Inherent jurisdiction and inherent powers are altogether different. So with respect to the inherent jurisdiction, we have section number 9. But if there is any express or implied bar on the jurisdiction of the civil court, if there is express or implied bar on the jurisdiction of civil court, then civil court is not going to entertain a civil matter. So this is the first thing which you people have to see, like what can be the express bar, what can be the implied bar. So whenever we are having any special law with respect to a particular subject matter, and a special court is also created for that particular thing, then it is ultimately that there is an express restriction on the jurisdiction of the civil court. They cannot entertain such kind of cases. Okay, so after this, do we have any recent judgments with respect to Section 9 or any landmark judgment? The answer is yes, we have some landmark judgments. I will be mentioning you people. That is Rajasthan State Road Transport Corporation Limited versus Balmukund Barwa. Balmukund Barwa. This case is of the year 2009 related with the concept that civil courts are having inherent jurisdiction to try all suits of civil nature unless there is an express or implied restriction on the civil courts. Another case that is a landmark case again, that is Gangabai versus Vijay Kumar. It is of the year 1974 Supreme Court, and again it is a landmark judgment of the same point related to section number 9 of the CPC. Then there are certain cases that which court will be a court of civil nature, which suit will be a suit of civil nature. So such kind of question also comes. So with respect to the suit of civil nature, we are having certain judgments. Number one, it is most reverend PMA Metropolitan, most reverend PMA Metropolitan versus Moram Marthoma. This judgment is again a very important judgment, landmark on the point that what kind of suits can be the suits of civil nature. It was of three judges bench, and the judgment was delivered by Justice R.N. Sahai. So you must have to consider these important judgments. And after that, on the point of express or implied bars, on the point of express or implied bars, we are having another important landmark judgment of the Honorable Supreme Court, that is Dhula Bhai versus State of Madhya Pradesh. It is of 1965 Supreme Court. It was of a five judges bench. Justice Hidayatullah has delivered this judgment, that is Dhula Bhai versus State of Madhya Pradesh. Now we have to see that okay, what with respect to which thing this judgment is important for us. Now, Section 9 is generally on the point, okay, that what civil suits can be tried by the civil court. Do every civil suit can be tried by the civil court? What are the suits of civil nature? So there is a general thing that is there in section number 9. Along with that, there is an explanation. Number 1 and 2 explanations are giving more some exhaustive kind of a meaning to the main provision of section number 9. That is that if you have to decide that whether a particular suit is a suit of civil nature or not, you have to decide it on the point that okay, if the right to property is associated or right to an office is associated, and that question is to be decided on the basis of the decision on some religious rites or ceremonies, still that suit will be called to be the suit of civil nature. Another thing is, if you are holding any right, any office, but no fees is attached to that office, it is immaterial whether to decide that whether the suit is of a civil nature or not. So, as per explanation number two, it is clearly stating that it is immaterial whether or not any fees is attached to a particular office or not. So, section 9 is again important with reference to the exams and the judgments which I had given you people. All those judgments are important because directly, most of the time in the multiple choice questions, the examiner used to put such kind of judgments to you. The next thing is section number 10. Now, what are the important things which can be there in the multiple choice question from section number 10? I will be mentioning you people. Section 10 is dealing with the concept of res sub judice. Okay, so what is res sub judice? It is basically the stay on the suit. When res sub judice will be applicable when the suit is altogether between the same parties is already pending in the court of law with respect to a particular matter in issue, and between the same parties another suit is filed in a court of concurrent jurisdiction. Then when the suit is being filed in the other court, that court has to stay the suit. But what kind of MCQs comes from section number 10? So just have some focus on these kind of questions. The first thing is that section 10 applies only once the issues are settled in a particular case. So the main point is section 10 comes into operation. Section 10 comes into operation after the settlement of issue. Most of the time, such kind of question comes that at what stage section 10 will be coming into force. So section 10 usually comes in force when the issues are settled in a particular case. The next thing is, do section 10 is mandatory for the court to observe? The answer is yes, section 10 is mandatory. The provisions of section 10 is mandatory in nature, and we have to adhere whatever the things which are mentioned in section number 10. So it is mandatory in nature. It is mandatory in nature. The next thing which you people have to follow, that it is a rule of procedure. Section 10 is a rule of procedure. So these are some important pointers with respect to the multiple choice question which people have to take care of. The next thing is section number 11, that is the primary principle of CPC, that is res judicata. Res judicata. So with respect to res judicata, there are some basic parameters which everyone is supposed to know, like what those basic factors are. Like if a matter is already decided between the parties, matter is directly and substantially in issue, and the same issue is raised subsequently in the court, subsequently, then the subsequent court is not going to decide the matter because already the res judicata is going to be applicable over there. But with respect to res judicata also, there are certain conceptual things the examiner used to put up, like is res judicata is procedural in nature? Please give me the answer in the comment box that do res judicata is procedural in nature or not? Do res judicata is procedural in nature or not? The answer is that res judicata is procedural in nature, and it is based upon the broader principle of the public policy. Res judicata is based upon the broader principle of public policy. So these are the two basic things you people have to understand, like what actually the res judicata is. So res judicata is number one, it is based upon the general principles of public policy. What kind of estoppel is created because of the res judicata? Do any one of you is aware of that? That what kind of estoppel is there because of the res judicata? Yes, anyone? Res judicata creates what kind of estoppel? So it creates estoppel by accord. It creates estoppel by accord. And there is a judgment on this particular point, that it creates an estoppel by accord, that is Bhanu Kumar Jain versus Archana Kumar. Bhanu Kumar Jain versus Archana Kumar. So this is the judgment on the point that do res judicata creates an estoppel. The answer is yes, it creates an estoppel, and that estoppel is by accord. Okay, or it is also called as estoppel by record also, because we have a judgment, and on the basis of that judgment, the honorable court is not competent to proceed with the matter. Now, there are some basic questions with respect to the res judicata, like under which provision the concept of constructive res judicata is there. Under which explanation of section 11, the concept of constructive res judicata is, so it is explanation number 4, that any matter which might or ought to have been made as a ground of defense or attack in such formal suit shall be deemed to have been a matter directly and substantially in the suit. So if there is an issue between the parties, but they are not raising that issue before the court of law, but they are supposed to do so. So once the judgment is passed, it will be considered that the court has passed the judgment on the issues which are raised by the parties or which have not been raised by the parties, but the parties were supposed to raise such issues. So that is where the concept of constructive res judicata will be applicable. Any important landmark judgment on the point of constructive res judicata in your knowledge? Yes, everyone. Any important landmark judgment on the constructive res judicata? You please mention in the chat box if you are aware of any landmark judgment. I will be giving you two judgments. One is Devilal Modi, Devilal Modi versus STO Ratlam, and others. It is of 1965 Supreme Court, a very, very important judgment on the concept of constructive res judicata. Another important judgment is State of UP versus Nawab Hussain. State of UP versus Nawab Hussain. So these two judgments, it is of the year 1977 Supreme Court. These two judgments might be asked to you in the MCQs also, like which case is related to the concept of constructive res judicata. I suppose that you are aware of such kind of things. Another explanation, that is, if you had asked a particular relief in your plaint from the court, but the court is silent upon that. Court is not expressly granted that relief to you. So it means that the court has refused to grant the relief. Market, that court has refused to grant the relief to you. The next thing is which explanation is related with the representative suits. So explanation number 6 is directly associated with the representative suit, that if there is a lot of persons who are having some public interest or private interest in common, and they are contesting a particular case, and the court has decided the case, and the judgment is passed. That judgment will be binding upon all the persons who are having the same kind of interest. Explanation 8, based upon the concept of executions, like on in the execution proceedings also the res judicata applies. And explanation number 8, that even if the court is only of a limited jurisdiction, still, the judgment passed by the court will operate as res judicata. It doesn't matter, the court is not competent to try the subsequent suit. So these are some important explanations, like explanation 4, 5, 6, 7, and 8, which you people have to see. Now, after this, there are certain issues which are being decided by the Honorable Supreme Court in judgments also, and you should be capable of understanding that what those issues are. I will be taking you people on the various judgments, like if the issue is heard by the court of limited jurisdiction, will operate as res judicata or not. Like explanation number 8 is there. Do we have any judgment on this point? The answer is yes. On explanation 8, we are having the judgment. On explanation 8, we are having the judgment, and the name of the judgment is Sulochana Amma versus Narayan Nair versus Narayan Nair. It is of the year 1994 Supreme Court, whereby the court held that even if a court is of the limited jurisdiction, still the judgment passed by the court is can operate as res judicata. The next thing is, do res judicata applies upon the erroneous decision of law? You please mention me in the comment box that do res judicata applies on the erroneous decision of the law? Yes, everyone. Do res judicata applies upon the erroneous decisions of the law? Those who are there in the session, please mention me in the live chat box that do res judicata applies on the erroneous decisions of law? Yes or no? Res judicata on erroneous decisions on law point. Will it apply or not? Are you aware of it or not? Yes, everyone. Those who are there in the session, in the live session, are you aware of this point that res judicata or an ordinance decision on law point will be applicable or not? Yes, it is the Isabella Johnson's case. Isabella Johnson versus M.A. Susai. It is of the year 1991, whereby the court held that no res judicata will be applicable if the court has delivered a judgment on the erroneous decision on a law point. Okay, no res judicata will apply. If the court is giving a judgment on the erroneous decision of law, no res judicata will be applicable. And there is another judgment on the same point, that is Mathura Prasad, Bajju Jaiswal versus Dosi Bhai. Mathura Prasad, Bajju Jaiswal versus Dosi Bhai, N.B. Gigi Bhoy. In this case also, in the year 1970, three judges bench, the judgment was delivered by Justice Shah, and they had held that if the court has given a judgment on the erroneous decision of law, that judgment will not be called as the res judicata, and the subsequent proceedings can be taken up by the court. Very important judgment. My next question to you people is: do res judicata apply between the co-defendants? Yes, everyone. Res judicata between co-defendants. You people must have to participate in the discussion. Do res judicata applies between the co-defendants? Yes or no? Do res judicata applies between the co-defendants? The answer is it may be applicable provided if the situation that in the previous suit the co-defendants are of the category that one is the performant, other one is the not, and the issue is decided between them. So in that scenario, the res judicata may be applicable between the co-defendants also. And the landmark case on the point is Mehboob Sahab versus Muhammad Ismail. Mehboob Sahab versus Muhammad Ismail. It is of 1995 Supreme Court, whereby the court had held that even between the co-defendants also the res judicata can be there. Res judicata can be there. Now the next thing is like coming to the Bail Act again. I hope you people are jotting down these judgments because these judgments are very important. Again, I'm repeating, and in the exams, not only in the Madhya Pradesh, rather in the other states also, such kind of questions are coming. The next thing is that what is the concept of foreign judgment, and do foreign judgment is directly applicable in India or not? The answer is that whatever is being decided by the foreign court and the foreign judgment is passed and the matter is directly adjudicated between the parties, the thing will be considered to be final and conclusive. The thing will be called to be final and conclusive, but there are certain situations where the rule of conclusiveness will not be applicable upon the parties. That is, if it has not been pronounced by the court of competent jurisdiction. So if the foreign court is having no jurisdiction to decide a matter, still they have passed the judgment. So that judgment will not to be called as a conclusive judgment in the India. The next thing is if the foreign court's judgment is not given on the merits of the case. The next one that if the foreign court has made the incorrect view of the international law or they have not recognized the Indian law. In that scenario also, the foreign court judgment will not to be called as conclusive in India. The next thing is if the proceedings which are there in the foreign court are opposed to the national justice, the parties are not being heard or the cross-examination, etc. is not options are not given. Next is if it is being obtained by fraud, and the next one is if there is a breach of any Indian law which is being done by the foreign court, then in that case also the judgment of the foreign court will not be conclusive. But if such kind of things are not there, then foreign judgment might be a conclusive judgment in India. You people tell me one thing that if there is a foreign court's judgment and the case was related to the money decree, under which provision of the CPC the direct executions are possible. You people will tell me in the comment box. The next thing is if any foreign court has delivered a judgment There is a presumption that once the certified copies are proved in the court of law, the certified copies are to be proved in the court with reference to section number 86 of the Indian Evidence Act. Once the certified copy is proved, the general presumption is that the court which passed the judgment has the competency to pronounce the judgment. So the court was competent court. It is the presumption which is there in section number 14 of the Code of Civil Procedure. So presumption will be taken up by the court only when the certified copies are produced in the court of law. And with respect to the certified copy, also we are having a presumption that is there in section number 86 of the Indian Evidence Act. The next thing is the place of suing, like where you can file a civil suit with respect to the civil matters. Section number 15, it is related with the pecuniary jurisdiction. So it is saying that the suit is to be instituted in the lowest grade court, which is who is competent to try. So section 15 is the rule of procedure. The rule of procedure. Sometimes the question can be there like which process is there in section number 15. So you might be having such questions in the exam also, and it is a rule of procedure which is there in section number 15. Section 16 is talking about wherever the subject matter situates, there you can file a suit subject to the pecuniary limits of the court. So what kind of suit section number 16 is talking about? Like whenever the suit is for the recovery of the immovable property with or without rents or profits. So if you are going to recover a property with or without rents or profits, you can file a suit wherever the property situates. If a suit is with respect to the partition of the immovable property, wherever the property situates, you can file a case. If a suit is with respect to foreclosure, sale, redemption, etc., then in that case, wherever the property situates, you can file a case, and foreclosure, sale, or redemption is related with the concept of the mortgage. The next thing is with respect to determination of any right with respect to the immovable property. So any right which is associated with the immovable property, it may be right of easement, it may be any other right. So wherever the property situates, there you can file a case. If any wrong is done to the immovable property, or if any recovery of movable property is to be done, which is under the attachment or dispute. So wherever the property is situated, there you can file a case. But there is a proviso. Proviso states that if the relief can be obtained only by the personal obedience of the defendant, like only if the defendant will be coming in the court, only then we can give the relief. Otherwise, awarding the relief is not possible. Then in that scenario, we can file a case wherever the defendant resides, carries on business, or personally works for gain. So this is the proviso which is there. The next thing is explanation. Like in section number 16, the property means what? Do the property which is situated outside India also will be covered? The answer is no. The property means the property situated within India only. The next thing is section number 17 is related with the point that if there is a property which is situated in the jurisdiction of more than two courts where the suit can be filed. So suit can be filed in any court which is having a jurisdiction over the matter, and that court has having the competency to take up the matter and to decide the entire claim of the party. Doesn't matter how much portion is there in the jurisdiction of the court. Next thing is section number 18 with respect to the uncertainty. So if there is an uncertainty with respect to the jurisdiction of the court has to record the reasons that okay, there is an uncertainty, and thereby the court can proceed with the matter. Section 19, important. Illustrations are again important. Like if the suit is with respect to wrong against a person or movable. So if you are doing a wrong against a person, it may be defamation, it may be beating someone, any tort which is being done against a person or property, where you can file a suit. The answer is given in section number 19, that is wherever the wrong done. Number one is wherever the wrong done. Number two, wherever the defendant resides, carries on business, personally works for gain. In such areas, the court will be having the jurisdiction to decide the matter. Section number 20, anything which is not being covered in section 16 till section 19, that will be falling under section number 20. So if any contractual kind of a dispute or any other dispute which is not there in section 16 till 19, so section 20 is a kind of a residuary clause. It is a kind of a residuary clause that wherever the defendant resides, carries on business, personally works for gain, there you can file a suit, or wherever the cause of action arises in wholly or in part. And there is another option, like if there are more than one defendant, wherever any defendant resides, any defendant carries on business or works for gain, there also we can file a civil suit against such person. So these are the basic things that you people have to see. Thereafter, the explanation is important. Now, what the explanation is stating, let me make you people more clear on the explanation part, because it is bit a question of interpretation in explanation. So it is saying that a corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arising at any place which is subordinate office at such place. So I will be making you people bifurcated this explanation to make you people understand that where a corporation shall be deemed to carry on business, where a corporation shall be deemed to carry on business. There was a case, New Moga Transport Corporation's case was there, in which the Honorable Supreme Court has clarified it. So there can be the corporations which are having the sole office or they're having the principal office, sole office or principal office, and there can be certain area businesses where the cause of action takes place in a subordinate office. So in such kind of a case, if the cause of action is arising at a subordinate office, then the suit can be filed over here. And if a particular business is having a sole office or a principal office, then and cause of action is arising at that particular area, then the case can be filed in the area wherever the sole or the principal office of the company is situated. So this is the broader clarification which is being given by the Honorable Supreme Court in the case of New Moga Transport Corporation, Transport Corporation versus United India Insurance, United India Insurance 2004 Supreme Court. So this case is again important because in this particular judgment, the interpretation of the explanation is being done by the Honorable Supreme Court. Thereafter, section number 21, which is related with the concept of the objections with respect to the jurisdiction. So if any person is having the objection with respect to the jurisdiction of the court, and that person raises the objection before the appellate or revisional court, do the appeal or revisional court will be allowed or not? Do such objection will be getting allowed or not? The answer is given in section number 21, and it is saying that if no objection is taken at the court of first instance at the earliest possible opportunity and before or at the time of settlement of the issues, and then you are raising the same objection in the revisional or appellate court. Like you have to raise the issue before the court of first instance, and if you have not raised it, you are going to the appellate or revisional court. The appellate or revisional court might not allow your objection unless and until there is a consequent failure of justice, and unless and until you had raised such issues before the trial court, that is the court of first instance. Now, section 21, subsection 1 is related with the point of place of suing. So it is on the point of territorial jurisdiction. The next subsection is with respect to the pecuniary jurisdiction, but it is not covering the subject matter jurisdiction. So if a civil court is not having a subject matter jurisdiction and still they had decided the matter, and then the objection is raised before the appellate or revisional court, the appellate or revisional court is going to allow that particular objection even if there is no consequent failure of justice, because subject matter jurisdiction is ultimately goes to the roots of the lack of jurisdiction, and it is the inherent lacking of jurisdiction which we usually understand. So that is basically the conceptual part, like how section number 21 works. But as it is a brief capsule class, so we have to see like, okay, what section number 21 is talking about, when the objections will be there in the appellate or revisional court, and do the appellate or revisional court is going to allow the objections or not. There will be three categories. Number one, you must have raised the objection before the first appellate court, court of first instance, and at the earliest possible opportunity, you might have raised that objection. And the third one is the court has not heard your objection and there is a consequent failure of justice to you. If such three situations coexist, there are three situations, and if these three situations are coexisting with each other, then in that scenario, if you go into the appellate or revisional court may allow your objection as per section number 21, and section number 99 of the CPC is also to be read together with this. So it is again a conceptual area, but in the general understanding, there are three conditions and all the conditions must coexist together. The next thing is section number 21 capital A, like if the court is having no jurisdiction to decide a matter, but you have not raised any objection to that, and subsequently you file a new suit for that. So section 21 is putting a restriction on the fresh suit. You cannot file a fresh suit to challenge the decree which is passed by the former in the former suit on the point that the court has no jurisdiction. Section number 22, like if there are more than one defendant and the suit is being filed in one of the court and one of the defendant want to get the suit to be transferred, so he can make an application for the transferring of the suit. So section 22 talks about it. Section 23 states in which particular court you will be filing an application. So if the courts are subordinate to the same appellate court, if the courts are subordinate to the same appellate court, then the application is to be given to the appellate court. If the courts are subordinate to different appellate courts, then the application for transfer is to be made to the high court, and the courts are subordinate to different high courts, like the court in which the case is and the court in which you want to get the case to be transferred. If these courts are subordinate to the different high courts, then the application is to be filed in the high court in whose jurisdiction the suit was first situated or suit was first brought. Okay. Thereafter, section number 24, general power of the High Court and of the District Court, that they can transfer any case or they can withdraw any case to them at any stage of the proceedings, and the case can be transferred from one judge to another judge. Section number 24, 25 talks about the power of the Supreme Court. What power that if the person makes an application to the Supreme Court for transferring a civil matter, they can go for that. But if you are making such applications which are frivolous applications, then the fine can be imposed which cannot be exceeding more than 2,000 rupees. From here, the MCQ can be there, like 2,000 रुपए से ज्यादा पैसे का जो compensation का order है वो नहीं दिया जा सकता under section number 25. Like, do section 25 is procedural or it is substantive? The answer is it is both. Section number 25 is substantive as well as it is procedural in nature. ठीक है, दोनों तरह का ये provision है, substantive as well as procedural. Durgeshwar Baba से Jayashree was the judgment in which the Honorable Supreme Court has clarified it. Now, coming to the next area of discussion, section number 26, institution of suit, directly associated with order number 4 of the CPC, like how the suit is to be instituted. So, by the presentation of plaint, the suit will be deemed to be instituted, and you have to present affidavit also along with the submission of the plaint. Section 27 to 32 relates with the summons, like how the summons will be given to the defendant. So where a suit is duly instituted, the summons will be issued to the defendant, and minimum 30 years period is to be given to the defendant to give his representation in the court of law. Section number 30 is with respect to the orders of discovery or inspection, etc. So if section number 30 is to be related, so it is related with order number 11, 12, and 13 of the Code of Civil Procedure. So court has the discretion that court may on its own motion or on the application of the party. Underline कर लेंगे, the court may on its own motion or on the application of party may pass an order for the discovery of the documents or things or inspection of the documents, production of the documents, etc. And if someone does not follow the direction of the court, or if someone not appears before the court despite the fact that court has ordered the person to appear, the court has the liberty under section 32 to issue warrant against that person, to attach and sell his properties, to impose fine upon him not exceeding rupees 5,000, or the court also has the discretion to commit such person to the civil prison. So these are the basic powers available to the court if any person violates the directions given by the court under section number 30 of the CPC. So 30 में बताया गया है क्या करना है, and the penalty is given in section number 32. Section number 33 generally saying that what is the judgment and decree. So every court, once the case is heard, they will be pronouncing a judgment, and once the judgment is there, the decree shall follow. So decree follows the judgment. Decree follows the judgment. Section number 34 with respect to the interest, like if the suit is with respect to the monetary transactions or payment of money, etc., like how the court is going to impose interest on the concerned amount, so there is a rule. I will be making you people bit clear of that, like what the rule is. So the court may order the court may order interest at such rate the court may order interest at such rate which it seems reasonable, which is reasonable, which appears to be reasonable to the court, which is reasonable in the terms of the court, but from how long you will be getting the interest. So it is saying that from the date of suit to the date of decree, from the date of suit to the date of decree. You can claim interest. The next thing is, in addition to this, in addition to this, the court has the discretion. The court has the discretion to award any interest prior to the period of institution of suit. Any interest prior to the institution of suit and and any future interest also, and any future interest also. So what will be the percentage of the interest which the court can award? कितने प्रतिशत का जो interest है वो court दे सकता है? So it is not exceeding 6%, not exceeding 6% on the principal amount, not exceeding 6% on the principal amount. 6% तक का जो ब्याज का अमाउंट है वो कोर्ट ऑर्डर कर सकता है प्रिंसिपल मूल राशि पे, प्रिंसिपल अमाउंट पे 6% और, लेकिन इससे ज्यादा कोर्ट नहीं करेगा। लेकिन लेकिन अगर पार्टीज की कॉन्ट्रेक्चुअल ट्रांजेक्शन कुछ और है, कॉन्ट्रैक्ट में कुछ और लिखा है, तो हम उस कॉन्ट्रेक्चुअल रेट को भी दे सकते हैं, प्रोवाइडेड बैंक रेट से ज्यादा हम पैसा नहीं दिलवा सकते। तो यहीं पे नीचे लिखेंगे, राइट डाउन दैट if the liability has arisen from the contractual transaction, if the liability has arisen from the contractual transaction, then the future interest मतलब सूट तो डिसाइड हो गया, लेकिन उसके बाद के टाइम के पीरियड के लिए भी आपको इंटरेस्ट का पैसा मिल सकता है। देन फ्यूचर इंटरेस्ट may exceed 6%, future interest may exceed 6%, but it will not exceed contractual rate. But it will not exceed contractual rate. ठीक है, तो एक छोटा सा प्रिंसिपल है कि आज मान लो एक व्यक्ति ने दूसरे व्यक्ति को 10,000 रुपया देना था, 10,000 नहीं दिया, कोर्ट में केस किया गया, कोर्ट ने ऑर्डर किया कि आपको पैसा देना। अब जिस दिन सूट फाइल किया और जब तक सूट डिसाइड होगा तब तक के लिए तो कोर्ट डिसाइड करेगा कि कितना परसेंट का ब्याज का पैसा दिलवाना है, लेकिन सूट फाइल होने से पहले का भी अगर कोई ब्याज दिलवाना है तो वो भी कोर्ट दे सकता है, और सूट डिसाइड होने के बाद पेमेंट तक अगर कोई ब्याज का पैसा मूल राशि पे दिलवाना है तो वो भी हम दिलवा सकते हैं, प्रोवाइडेड वो 6% तक रहेगा। 6% से वो बढ़ाया जा सकता है अगर कॉन्ट्रेक्चुअल ट्रांजेक्शन में ऐसा कुछ लिखा हुआ है, लेकिन कॉन्ट्रैक्ट में जो रेट लिखा है उसके ज्यादा आप ब्याज का पैसा नहीं मांग सकते। और एक दूसरी इंपॉर्टेंट चीज है कि मान लीजिए कोर्ट ने फ्यूचर इंटरेस्ट आपको नहीं दिया, if the court has not given you the future interest, then in that case it will be deemed to be refused. If the court has not granted future interest, if the court has not granted future interest, then it shall be deemed to be refused. ये लिखा भी आपके बेरेक में, आप मार्क कर लेंगे। If the decree is silent upon the point with respect to further interest or future interest, then it shall be deemed to have been refused and a separate suit shall not lie. ठीक है, तो इस चीज के लिए दोबारा बाद में मुकदमा नहीं किया जा सकता। So these are the basic things with respect to interest. The next point is cost. Cost में MCQs में क्या क्या पूछी जाती है चीजें, just understand that. look, if a court is having jurisdiction to decide a matter or the court has no jurisdiction to decide a matter, तब भी court जो है cost लगा सकता है. लिखा है the court has, even if the court has no jurisdiction to try the suit, it shall have no bar to exercise such power. The power is the power of imposing cost upon the party. इसके साथ साथ when the cost is to be imposed, तो एक चीज कही जाती है that cost follows the event. और अगर cost event को follow नहीं कर रहा है तो कोर्ट को reasons लिखने पड़ते हैं. The meaning is that if any new thing is there introduced in the court of law, the court has to award cost for that. And if the court is not awarding cost or not, the court is not imposing cost over the party, then in that case the court has to record the reasons for the same. Cost जब भी कोर्ट नहीं लगाता है तो कोर्ट को रीजंस लिखने होते हैं कि कोर्ट कॉस्ट क्यों नहीं लगा रहा है. इसके साथ साथ कंपनसेटरी कॉस्ट कि if any person is raising vexatious or false claims before the court of law or any false or vexatious defense is raised in the court of law, the concerned person is entitled to get compensation for that, but the amount of compensation cannot exceed rupees 3,000 or the pecuniary jurisdiction of the court. तो इस चीज का भी ध्यान रखना है. लाइक 35 कैपिटल में किस चीज का जिक्र किया गया है, कंपनसेटरी कॉस्ट की बात है. The next thing which is important for you people, that if the person is raising vexatious claims in the court and the court has imposed cost upon the party, do the party is exempted from the criminal liabilities also? The answer is no. अगर किसी व्यक्ति विशेष के ऊपर गलत क्लेम्स करने की वजह से कोर्ट ने कॉस्ट इम्पोज किया है तो कॉस्ट तो कोर्ट ने लगा दिया, लेकिन क्या उसकी क्रिमिनल लाइबिलिटीज खत्म हो गई? द आंसर इज नो. नो पर्सन इज एग्जम्प्टेड फ्रॉम द क्रिमिनल लाइबिलिटीज merely because the cost has been imposed upon him. Section number 35, capital B, related to the principle that is cost for causing delay, that if the court has asked you to do something but you are not doing that thing, अगर कोर्ट ने आपको कुछ काम करने के लिए कहा और आप वो काम नहीं किए हैं, आप एडजर्नमेंट मांग रहे हैं, आप एविडेंसेस लेके कोर्ट में नहीं आए, तो आपके ऊपर कॉस्ट फॉर कॉजिंग डिले जो है वो 35 कैपिटल बी के अंदर लगाया जा सकता है. अगर कॉस्ट फॉर कॉजिंग डिले आपके ऊपर लगा दिया गया तो ये कंडीशन प्रेसिडेंट बन जाता है. कंडीशन प्रेसिडेंट बन जाता है कि आपको अगर केस आगे चलाना है, इफ यू वांट टू परस्यू द केस फर्दर, आपको कॉस्ट पे करना ही पड़ेगा. सो दीज आर द बेसिक थिंग्स विद रिस्पेक्ट टू द कॉस्ट. इसके बाद आपका जो नेक्स्ट पार्ट है, पार्ट नंबर 2, एग्जीक्यूशन को लेके वो शुरू होता है. पहली चीज जो यहाँ पे आपके लिए रेलेवेंट है, सेक्शन नंबर 38 और 39 में आप लोग आएंगे. डिक्री में भी एग्जीक्यूटेड, कौन सी कोर्ट डिक्री एग्जीक्यूट कर सकती है? तो या तो जिस कोर्ट ने डिक्री पास किया है और या फिर जिस कोर्ट को डिक्री सेंट भेजा गया है एग्जीक्यूशन पर्पसेस के लिए. सो द कोर्ट व्हिच हैज पास द डिक्री और द कोर्ट टू व्हिच द डिक्री सेंट फॉर एग्जीक्यूशन, दोस कोर्ट्स आर कॉम्पिटेंट टू एग्जीक्यूट द डिक्री. दूसरी सिचुएशन है कि व्हेन यू विल बी ट्रांसफरिंग द डिक्री फॉर एग्जीक्यूशन, आप किसी भी डिक्री को ट्रांसफर कब कर दोगे? तो देखो, अगर व्यक्ति विशेष को अरेस्ट करवाना है एग्जीक्यूशन के दौरान और व्यक्ति विशेष कोर्ट की जुरिस्डिक्शन में नहीं रहता है, द पर्सन इज नॉट रिजाइडिंग विद इन द जुरिस्डिक्शन ऑफ द कोर्ट, तो आप उसको अरेस्ट नहीं कर सकते. तो जिस भी कोर्ट की जुरिस्डिक्शन में व्यक्ति विशेष रहता है उस कोर्ट को आपको मैटर भेजना पड़ेगा और वही कोर्ट अरेस्ट करने का ऑर्डर दे सकती है. अगर किसी प्रॉपर्टी को अटैच या सेल करवाना है, द प्रॉपर्टी इज रिक्वायर्ड टू बी अटैच्ड एंड सोल्ड, so wherever the property situates, only that court is having the competency to go for the attachment and sale of the property. बाकी कोर्ट अटैचमेंट और सेल नहीं कर सकती जिनकी जुरिस्डिक्शन में प्रॉपर्टी सिचुएट नहीं करती है. इसके साथ साथ सेक्शन नंबर 44 कैपिटल ए में आप लोग आओगे. 44 कैपिटल ए, ये एग्जीक्यूशन ऑफ द डिक्रीज पास बाय द कोर्ट्स इन द रेसिप्रोकेटिंग टेरिटरीज की बात करता है. बेसिकली फॉरेन कोर्ट्स ने अगर कोई जजमेंट पास किया है जो मनी डिक्री से रिलेटेड है, मनी डिक्री मींस व्हाट, दैट फॉरेन की कोर्ट ने ये डिसाइड किया है कि ए को बी से पैसा मिलेगा, तो उस कोर्ट के जजमेंट को, फॉरेन कोर्ट के जजमेंट को इंडिया में डायरेक्टली आप एग्जीक्यूट करवा सकते हो. तो ये एक तरीका है डायरेक्ट एग्जीक्यूशन का. फॉरेन कोर्ट की जजमेंट को इंडिया में डायरेक्टली कैसे एग्जीक्यूट करवाया जा सकता है. द नेक्स्ट इंपॉर्टेंट एरिया फॉर यू पीपल इज सेक्शन नंबर 46. 46 में प्रिसेप्ट ऑर्डर. प्रिसेप्ट, कैन एनीवन ऑफ यू टेल मी दैट व्हाट इज द टाइम ड्यूरेशन फॉर द ऑर्डर ऑफ प्रिसेप्ट? आप में से कोई बता सकता है कि प्रिसेप्ट की टाइमलाइन कितनी होती है? यस, एनीवन ऑफ यू? व्हाट इज द टाइमलाइन फॉर प्रिसेप्ट? सेक्शन नंबर 46 के हिसाब से प्रिसेप्ट क्या है? सो प्रिसेप्ट मींस कि देखो, एक कोर्ट ने एक जजमेंट पास किया, अब उस जजमेंट का एग्जीक्यूशन होना है, लेकिन जो प्रॉपर्टी हमें अटैच करनी है वो प्रॉपर्टी उस कोर्ट की जुरिस्डिक्शन में नहीं आती है. जैसे उदाहरण के तौर पे, देयर इज अ कोर्ट इन दिल्ली जिस कोर्ट ने जो केस पास डिसाइड किया ए के फेवर में, ए चाहता है कि बी की प्रॉपर्टी अटैच हो जाए, ए चाहता है बी की प्रॉपर्टी अटैच हो जाए, लेकिन बी की प्रॉपर्टी उस कोर्ट के दायरे में नहीं आती है। सो इन दैट सिनेरियो ए को क्या करना पड़ेगा, व्हाट मिस्टर ए हैज टू डू, उसको या तो डिक्री को ट्रांसफर करवाना पड़ेगा। तो अगर डिक्री ट्रांसफर हो जाती है, फिर उसके बाद जिस कोर्ट में आप एग्जीक्यूशन लगाओगे वो कोर्ट अटैच कर लेगी। बट द पॉइंट इज, अगर उसमें समय लगना है तो आप जिस कोर्ट ने जजमेंट पास किया है उसी कोर्ट से प्रिसेप्ट का ऑर्डर ले सकते हैं। सो वंस द ऑर्डर ऑफ प्रिसेप्ट इज बीइंग ऑब्टेन्ड बाय यू, व्हाट विल बी द इम्पैक्ट, कि एक टेम्परेरी अटैचमेंट का प्रोसेस होता है, टेम्परेरी अटैचमेंट का। द कोर्ट विच पासिस द डिक्री will issue a direction to the court in whose jurisdiction the property situates to kindly attach the property for a time being। तो जिस कोर्ट के दायरे में वो प्रॉपर्टी है उसको कोर्ट को टेम्परेरी बेसिस पे अटैचमेंट करने के लिए बताया जाता है। तो 2 महीने तक का ये प्रॉपर्टी जो है ये अटैच किया जा सकता है। दैट नो अटैचमेंट अंडर द प्रिस्क्रिप्शन शैल कंटिन्यू फॉर मोर देन 2 months। अब 2 महीने के अंदर अंदर अगर तो जिस कोर्ट ने ये अटैचमेंट किया उसको डिक्री ट्रांसफर होके आ गई एग्जीक्यूशन पर्पसेस के लिए, तो वो आगे कंटिन्यू करेगा। और अगर दोबारा से आपने प्रिसेप्ट को रिफ्रेश करवाना है, री इशू करवाना है, तो उसके लिए दोबारा से सेम प्रोसेस सेक्शन 46 की एप्लीकेशन लगा के आप कर सकते हैं। एग्जाम में जनरली जो सवाल आता है वो ये आता है कि प्रिसेप्ट ऑर्डर कितने समय तक के लिए कंटिन्यू किया जाता है। तो इट इज प्राइमरली द 2 months पीरियड। इसके बाद प्रिसेप्ट के ऑर्डर की कोई वैलिडिटी नहीं है अनलेस एंड अनटिल जिस कोर्ट ने अटैचमेंट किया है उस कोर्ट में डिक्री आ चुकी है और वो कोर्ट एग्जीक्यूशन करने के लिए कैपेबल बन चुकी है, या फिर दोबारा से आपने प्रिसेप्ट के ऑर्डर को कोर्ट से इशू करवाया हो। सेक्शन नंबर 47, क्वेश्चन विद रिस्पेक्ट टू द एग्जीक्यूशन कौन डिसाइड करेगा, सिर्फ एग्जीक्यूटिंग कोर्ट डिसाइड करेगी। एनी क्वेश्चन रिलेटेड टू द एग्जीक्यूशन, डिस्चार्ज एंड सैटिस्फैक्शन ऑफ द डिक्री, ओनली एग्जीक्यूटिंग कोर्ट हैज द कॉम्पिटेंसी टू डिसाइड इट। किसी भी व्यक्ति की अगर एग्जीक्यूशन के प्रोसीडिंग्स के दौरान, मतलब डिक्री होल्डर और जजमेंट लेटर की अगर डेथ हो जाए, सो हु विल बी द रिप्रेजेंटेटिव सही व्यक्ति बना या नहीं, सो ऑल दीज थिंग्स विल बी डिसाइडेड बाय द एग्जीक्यूटिंग कोर्ट ओनली। ठीक है, इसके साथ साथ एक्सप्लेनेशन 1 and 2 आर इंपॉर्टेंट फॉर यू पीपल कि अगर एग्जीक्यूशन के दौरान कोई भी व्यक्ति प्रॉपर्टी परचेज करता है तो वो व्यक्ति भी पार्टी टू द प्रोसीडिंग्स माना जाता है। सच पर्सन इज डीम्ड टू बी द पार्टी टू द प्रोसीडिंग्स हूएवर इज द ऑक्शन परचेजर। ठीक है, तो ये बेसिकली ऑक्शन एग्जीक्यूशन से रिलेटेड है। सेक्शन नंबर 49 में ट्रांसफरी की बात है। नाउ विद रिस्पेक्ट टू द ट्रांसफरी एक छोटा सा प्रिंसिपल है, सेक्शन नंबर 49 से कभी कभी पूछ लिया जाता है कि रूल ऑफ इक्विटी कहां पे है। तो इक्विटी का प्रिंसिपल सेक्शन नंबर 49 के अंदर है कि मैं एक छोटा सा लाइन यहां पे आपको लिखवा सकता हूं, दैट एवरी डिक्री विच इज ट्रांसफर्ड टू अ पर्सन। ठीक है, जैसे एक व्यक्ति के पास डिक्री आ गया, दैट पर्सन गॉट अ डिक्री फ्रॉम द कोर्ट, वो चाहे तो अपनी डिक्री किसी और को ट्रांसफर भी कर सकता है। सो एवरी डिक्री ट्रांसफर टू अ पर्सन will be called as ट्रांसफरी। अगर किसी व्यक्ति को डिक्री ट्रांसफर होकर मिला है, किसी ने उसको डिक्री दिया है, तो दैट पर्सन विल बी कॉल्ड टू बी अ ट्रांसफरी ऑफ द डिक्री। एंड ट्रांसफरी कैन enforce the same as judgment debtor might have enforced transferee can enforce the same as judgment debtor might have enforced against the decree holder। ठीक है, तो जैसे डिक्री होल्डर और जजमेंट डेटर के बीच में जो ट्रांजैक्शन थी, अगर जजमेंट डेटर डिक्री होल्डर के अगेंस्ट कुछ चीजें एग्जीक्यूट करवा सकता है, कुछ इन्फोर्समेंट करवा सकता है, तो अगर वो डिक्री ट्रांसफर हो चुकी है तो ट्रांसफरी भी डिक्री होल्डर के अगेंस्ट अपने वो राइट्स को इन्फोर्स करवा सकते हैं, क्योंकि जजमेंट डेटर ने डिक्री कहां ट्रांसफर कर दी, ट्रांसफरी को दी। ठीक है, तो जैसे ए नाम का व्यक्ति है, ये डिक्री होल्डर है, बी नाम का व्यक्ति है, ये जजमेंट डेटर। तो अगर ए डिक्री होल्डर बी के अगेंस्ट डिक्री एग्जीक्यूट करवा सकता है, तो बी के पास भी अगर कुछ सेट ऑफ एक्सेट्रा करवाने का तरीका है तो ये करवा ले। लेकिन अगर बी ने ये डिक्री ट्रांसफर कर दी किसी एक्स नाम के व्यक्ति को, तो जो राइट्स बी के थे वो सारे राइट्स किसके पास चले गए, एक्स के। और एक्स बी ए से वैसे ही काम कर सकता है जैसे जजमेंट डेटर कर सकता था। तो इसी को कहा जाता है इट इज अ रूल ऑफ इक्विटी विच इज अवेलेबल टू द ट्रांसफरी ऑफ पर्टिकुलर मैटर। सेक्शन नंबर 50 के अंदर लीगल रिप्रेजेंटेटिव की बात है कि अगर कोई भी जजमेंट डेटर डिक्री सेटिस्फाई अभी तक नहीं हुई थी, जजमेंट डेटर की डेथ हो जाती है, सो द डिक्री कैन बी एग्जीक्यूटेड अगेंस्ट द लीगल रिप्रेजेंटेटिव ऑफ द डिसीज पर्सन। जिस भी व्यक्ति को डिसीज की प्रॉपर्टी मिली है उसी व्यक्ति के अगेंस्ट वो डिक्री एग्जीक्यूट की जा सकती है। सेक्शन नंबर 51 पावर्स ऑफ द कोर्ट विद रिस्पेक्ट टू द एनफोर्समेंट ऑफ द एग्जीक्यूशन की बात कर रहा है कि कैसे कैसे डिक्री को एग्जीक्यूट किया जा सकता है। मध्य प्रदेश छत्तीसगढ़ में ये पहले भी सवाल आया हुआ है, ठीक है, तो जिसमें एक सवाल पूछा गया था कि बट आर द मोड्स ऑफ एग्जीक्यूशन, तो डिलीवरी ऑफ द प्रॉपर्टी, तो अगर प्रॉपर्टी से रिलेटेड मैटर है तो डिलीवरी ऑफ द प्रॉपर्टी कैन बी देयर, अटैचमेंट एंड सेल विदाउट अटैचमेंट, इसको जरूर मार्क आप लोग अपने बेरेक में करना है। यहाँ से सवाल जनरली आ जाता है कि क्या अटैचमेंट होने के बाद ही सेल होता है, तो अटैचमेंट होने के बाद तो सेल होता ही है, लेकिन कभी कभी बिना अटैचमेंट के भी सेल किया जा सकता है प्रॉपर्टी। नेक्स्ट वन इज अरेस्ट एंड डिटेंशन, नेक्स्ट वन इज रिसीवर के अपॉइंटमेंट भी हम कर सकते हैं। लेकिन जब भी आपको अरेस्ट और डिटेंशन करना है तो आपको सबसे पहले शो कॉज नोटिस भेजना पड़ेगा। बिना शो कॉज नोटिस दिए यू कैन नॉट अरेस्ट द जजमेंट डेटर। सेक्शन 52 इन्फोर्समेंट ऑफ अ डिक्री अगेंस्ट एलआर की बात कर रहा है कि अगर डिक्री होल्डर ने डिक्री को एग्जीक्यूट करवाना था, जजमेंट डेटर की डेथ हो चुकी है, जजमेंट डेटर इज नो मोर, जजमेंट डेटर की जो प्रॉपर्टी थी वो उसके लीगल रिप्रेजेंटेटिव्स को मिली, तो लीगल रिप्रेजेंटेटिव्स के पास आप जो है एग्जीक्यूशन के लिए केस कर सकते हो उनके ऊपर। बट द पॉइंट इज कि अगर लीगल रिप्रेजेंटेटिव ने प्रॉपर्टीज को ड्यूली डिस्पोज किया है, मतलब किसी अच्छे चीज के लिए डिस्पोज ऑफ किया है, जो जजमेंट डेटर की ही लाइबिलिटीज थी उनको लेके डिस्पोज किया है, तो लीगल रिप्रेजेंटेटिव्स के अगेंस्ट एग्जीक्यूशन पॉसिबल नहीं हो पाएगा। लेकिन अगर डिग्री होल्डर ने ये जो एग्जीक्यूशन को इनिशिएट किया और जजमेंट डेटर की डेथ हो चुकी है, लीगल रिप्रेजेंटेटिव के पास कोई प्रॉपर्टी नहीं है और उसके पास कोई सफिशिएंट रीजन नहीं है एक्सप्लेनेशन देने का, तो हम लीगल रिप्रेजेंटेटिव के अगेंस्ट ही उस डिक्री को एग्जीक्यूट कर देंगे और माना जाएगा कि डिक्री एलआर के अगेंस्ट ही पास हुई। सेक्शन नंबर 53 लाइबिलिटी ऑफ द एंसेस्ट्रल प्रॉपर्टी की बात कर रहा है कि कोई भी प्रॉपर्टी जो एंसेस्ट्रल प्रॉपर्टी है उससे लेके कोई डिस्प्यूट था, कोई रिकवरी का मैटर है, तो वही रिकवरी सन, ग्रैंडसन, ग्रेट ग्रैंडसन एक्सेट्रा के अगेंस्ट हम कर सकते हैं। सेक्शन नंबर 54 पार्टीशन की बात कर रहा है, तो पार्टीशन अगर कभी भी करवाना होगा तो इट विल बी डन बाय द कलेक्टर और एनी ऑफिसर डेप्यूटेड बाय द कलेक्टर, तो 54 इज ऑन दैट पॉइंट। 55 आपका अरेस्ट एंड डिटेंशन की बात है, जनरल सेक्शन आपको ध्यान में रखना है कि अरेस्ट एंड डिटेंशन कहाँ पे है, किस व्यक्ति को अरेस्ट नहीं किया जा सकता, तो मनी डिक्री के केसेस में महिलाओं को अरेस्ट नहीं किया जा सकता है। इन द केस ऑफ मनी डिक्री वुमेन कैन नॉट बी अरेस्टेड। सेक्शन नंबर 57 सब्सिस्टेंस अलाउंस की बात कर रहा है कि अगर डिक्री होल्डर ने जजमेंट डेटर को अरेस्ट करवाने के लिए कोर्ट में एप्लीकेशन लगाई, कोर्ट ने उसको अरेस्ट करने का ऑर्डर भी दे दिया, लेकिन जजमेंट डेटर को जेल में रखने का खर्चा डिक्री होल्डर को ही उठाना पड़ता है, उसी को हम सब्सिस्टेंस अलाउंस कहते हैं। नेक्स्ट पॉइंट है आपका कि किस व्यक्ति को कितने समय तक आप जो है जेल में रख सकते हैं, सिविल प्रिजन में रख सकते हैं, तो सेक्शन नंबर 58 उसका आंसर देता है। सेक्शन नंबर 58 विच टॉक्स अबाउट द पॉइंट कि अगर डिक्री 5,000 रुपए से ज्यादा की थी, मोर देन 5,000 रुपीज, तो 3 महीने तक मैक्सिमम 3 महीने तक आप डिटेंशन के लिए रख सकते हैं। अगर 2,000 से 5,000 तक का रिकवरी का केस था तो आप डिटेंशन पीरियड 6 हफ्ते का रखते हैं, और अगर लेस देन 2,000 का केस है आपका तो ऐसे केसेस में कोई सिविल प्रिजन नहीं और कोर्ट ऑर्डर करती है। ठीक है, इसके साथ साथ कब कब व्यक्ति को रिलीज कर दिया जाता है, तो अगर उसने ऑफिसर इंचार्ज ऑफ द प्रिजन को पैसे दे दिए हैं तब उसको रिलीज कर दिया जाएगा, अगर वो सब्सिस्टेंस अलाउंस पे नहीं कर रहा है तब उसको रिलीज कर दिया जाएगा, अगर वो व्यक्ति जिसकी कारण से जेल में भेजा गया, डिग्री होल्डर ही अगर रिक्वेस्ट कर दे कि सर इसको जेल से रिलीज कर दो तब भी किया जा सकता है, और या फिर सीरियस इलनेस के ग्राउंड पे सेक्शन 59 कहता है कि हम ऐसे व्यक्तियों को रिलीज कर सकते हैं। इलनेस की जब बात आएगी तो हम अगर कोई भी व्यक्ति किसी इन्फेक्शियस डिसीज से सफर कर रहा है तो स्टेट गवर्नमेंट उस व्यक्ति के रिलीज का ऑर्डर बना सकती है, और अगर कोई भी व्यक्ति सीरियस इलनेस में है तो जिस भी कोर्ट ने उसको जेल में भेजा था वो कोर्ट रिलीज करने का ऑर्डर दे सकती है। कोई भी व्यक्ति जिसको इलनेस के ग्राउंड्स पे आपने अरेस्ट किया था अगर उसको रिलीज करना है तो कर सकते हो, लेकिन प्रोवाइडेड उसको बाद में री अरेस्ट किया जा सकता है, लेकिन मैक्सिमम पीरियड ऑफ डिटेंशन वही रहेगा जो सेक्शन 58 के अंदर बताया गया। इसके बाद सेक्शन नंबर 60 आपके लिए इंपॉर्टेंट है। सेक्शन 60 में which properties are attachable, which properties are non attachable, this is very important। लिस्ट का आपको ध्यान रखना पड़ता है। जनरली जो फर्स्ट पैराग्राफ में चीजें हैं ये प्रॉपर्टीज अटैचेबल हैं। और इसके नीचे जो प्रोवाइजो में चीजें हैं, जैसे क्लॉज नंबर ए में बियरिंग, कुकिंग वेसल्स, बेड बेडिंग, टूल्स ऑफ आर्टिजन एक्सेट्रा, ये सब जो है ये नॉन अटैचेबल रहते हैं। इसमें भी जो सबसे पहले आपको ध्यान में चीज रखनी है, दैट इज क्लॉज नंबर आई एंड आई ए, कि अगर मेंटेनेंस का केस है तो 1/3 ऑफ द सैलरी अटैच नहीं होगा। मेंटेनेंस के केस में 1/3 ऑफ द सैलरी अटैच नहीं होगा। बट अदर केसेस में अगर सैलरी अटैच करना है तो कितना एग्जाम्प्टेड है, तो फर्स्ट 1000 एंड 2/3 ऑफ द रिमाइंडर आप अटैच नहीं कर सकते, बाकी का सारा सैलरी अटैच किया जा सकता है। कोई भी LIC, कोई भी पर्सनल प्रोविडेंट फंड एक्सेट्रा जो है वो अटैच नहीं किए जा सकते, बिकॉज वो व्यक्ति के फ्यूचर के लिए है, तो उनको अटैच नहीं किया जाएगा। सेक्शन 60 के अंदर वो सब एग्जाम्पशन में है। सेक्शन नंबर 61 पार्शियल एग्जाम्पशन ऑफ एग्रीकल्चर प्रोड्यूस के ऊपर है। कोई भी व्यक्ति जो एग्रीकल्चरिस्ट है, जो भी उसने फसल अपनी निकाली है, तो फसल जो है वो पार्शली अटैच हो सकती है, पार्शली नहीं होगी, क्योंकि उस व्यक्ति को अपने लाइवलीहुड के लिए आधी जो फसल है वो रखने का अधिकार दिया गया। सेक्शन नंबर 62 डीलिंग विद द कॉन्सेप्ट ऑफ सीजर ऑफ द प्रॉपर्टी इन द ड्वेलिंग हाउसेज। तो ड्वेलिंग हाउस में मतलब जहां पे कोई व्यक्ति विशेष रहते हैं, वहां पे अगर आपको कोई सीजर करना है तो किसी भी ड्वेलिंग हाउस में सनसेट या सनराइज के बीच में आप नहीं जाएंगे। ये जो सनसेट के बाद ही आप जा सकते, सनराइज के बाद ही आप जा सकते हैं। सेक्शन नंबर 64 प्राइवेट एलिनेशन ऑफ द प्रॉपर्टी आफ्टर अटैचमेंट इज टू बी वॉइड, कि अगर कोर्ट ने एक प्रॉपर्टी अटैच कर दी है और अटैचमेंट होने के बावजूद भी पार्टी वहां पे प्रॉपर्टी को एलिनेट करने की कोशिश कर रही है, तो वो एलिनेशन वॉइड माना जाएगा। लेकिन लेकिन अगर पार्टीज के बीच में एग्रीमेंट हो चुका है, ट्रांजेक्शन हो चुकी है, रजिस्टर हो चुका है डॉक्यूमेंट, और उसके बाद अगर अटैचमेंट होता है, तो वहां पे फिर वो ट्रांजेक्शन वैलिड रहेगी, वो वॉइड नहीं होगी। सेक्शन नंबर 65 परचेजर के टाइटल की बात करता है कि अगर डिक्रीज के एग्जीक्यूशन के दौरान किसी व्यक्ति ने प्रॉपर्टी खरीदी, तो उसको टाइटल कब से मिलेगा, तो टाइटल मिलेगा, यहाँ पे अगर हम पूरा पढ़े तो लिखा है whether immovable property is sold in the execution of the decree and the sale becomes absolute। सेल एब्सोल्यूट होने में समय लगता है। सेक्शन ऑर्डर नंबर 21 का रूल नंबर 92 बताता है कि सेल एब्सोल्यूट कब होगी। लेकिन द परचेजर विल गेट अ टाइटल फ्रॉम द डे व्हेन द प्रॉपर्टी इज सोल्ड, जिस दिन उसने प्रॉपर्टी खरीद ली है ऑप्शन में, उसी दिन से वो मालिक बन चुका है, नॉट फ्रॉम द डेट व्हेन द सेल बिकम्स एब्सोल्यूट। स्टार लगा लो, यहाँ से MCQ आपके बहुत बार बनाए जाते हैं। Thereafter, come to section number 73 कि रेटेबल डिस्ट्रीब्यूशन ऑफ द प्रॉपर्टी होता है कि अगर एक से ज्यादा लोगों के पास एक ही व्यक्ति के अगेंस्ट डिक्री है, लाइक देयर इज अ वन पर्सन हु इज द जजमेंट डेटर एंड देयर आर मोर देन वन पर्सन हु आर देयर द डिक्री होल्डर्स, तो जब डिक्री के एग्जीक्यूशन के लिए वो अप्लाई करेंगे और एक ही प्रॉपर्टी या कुछ एक एसेट से ही आपको एग्जीक्यूशन करवाना है, तो उस केस में जो प्रॉपर्टी है उसको बेच के जो आएगा उसको रेटेबली प्रोपोर्शन बना के हम डिस्ट्रीब्यूट करते हैं। ये सेक्शन नंबर 73 हमें बताता है। तो सेक्शन 73 इज ऑन द कॉन्सेप्ट ऑफ दैट हाउ द रेटेबल डिस्ट्रीब्यूशन इज टू बी डन। अब रेटेबल डिस्ट्रीब्यूशन में बेसिक पॉइंट ये होता है दैट एसेट्स ऑफ द पर्सन इज लेस एंड द लायबिलिटीज आर मोर, तो उस केस में रेटेबल डिस्ट्रीब्यूशन प्रोपोर्शन करके करना पड़ता है। तो हमें देखना पड़ता है कि किस डिग्री होल्डर का कितना रेशियो है, उस हिसाब से हमें डिक्री को एग्जीक्यूट करवाना है। सेक्शन 74 रिस्पेक्ट टू द रेजिस्टेंस टू द एग्जीक्यूशन। रेजिस्टेंस टू द एग्जीक्यूशन मींस कि आप कोर्ट ने डिक्री पास कर दिया, आप एग्जीक्यूशन पर्पस के लिए इनिशिएट करते हो, लेकिन कोई व्यक्ति कोर्ट के उस ऑर्डर की अवहेलना कर रहा है, द पर्सन इज ऑब्स्ट्रक्टिंग द एग्जीक्यूशन प्रोसेस और ही इज रेजिस्टिंग टू दैट, देन इन दैट सिनेरियो the application can be there in the civil court under section number 74, and the court has the liberty to order civil prison for a term which will not extend more than 30 days। तो 30 दिन तक व्यक्ति विशेष को सिविल प्रिजन में रखा जा सकता है। सेक्शन नंबर 75 कमीशन कब कब भेजे जा सकते हैं, तो डायरेक्टली आपको यहाँ पे देखना है, टू एग्जामिन एनी पर्सन, टू मेक लोकल इन्वेस्टिगेशन, एडजस्ट अकाउंट्स अगर करने हैं तो उसमें कमिश्नर की बात हो सकती है। पार्टीशन करने के लिए कमीशन इशू किए जाते हैं, साइंटिफिक टेक्निकल या एक्सपर्ट इन्वेस्टिगेशन के लिए किया जा सकता है। टू कंडक्ट द सेल ऑफ द प्रॉपर्टी या फिर टू परफॉर्म द मिनिस्ट्रियल फंक्शंस। तो हमारा CPC का ऑर्डर नंबर 26 है, जो कमीशन कब इशू करने हैं, किसके लिए करने हैं, उसके लिए बात करते हैं। सेक्शन नंबर 79 आपको ध्यान में रखना है, सूट्स बाय और अगेंस्ट गवर्नमेंट। सेक्शन 80 में नोटिस पीरियड आपका कितना रहेगा, तो नोटिस पीरियड विल बी ऑफ 2 मंथ्स। बिना नोटिस पीरियड खत्म हुए आप सरकार के ऊपर दावा पेश नहीं कर सकते। किसको पार्टी बनाना है, तो अगर सेंट्रल गवर्नमेंट का मैटर है तो सेक्रेटरी टू द गवर्नमेंट को आप पार्टी बनाओगे, अगर स्टेट का है तो सेक्रेटरी टू द स्टेट गवर्नमेंट को या कलेक्टर को पार्टी बनाओगे, और अगर रेलवे का है तो जनरल मैनेजर ऑफ द रेलवे को पार्टी बनाओगे। अगर जम्मू एंड कश्मीर की सरकार के ऊपर चीज करना है तो चीफ सेक्रेटरी को हम पार्टी बनाएंगे। इसके साथ साथ अगर इमीडिएट या अर्जेंसी का मैटर है और 2 महीने का समय खत्म नहीं हुआ, द 2 months पीरियड इज नॉट येट एक्सपायर्ड and the matter is of urgency, then you can make an application. The court has the discretion to admit your suit, but the court will not be granting any relief to you unless and until the court is giving an option to the public servant or to the government to come to the court. तो आपको रिलीफ तो नहीं मिलेगा, लेकिन आप सूट फाइल कर सकते हो unless and until वो कोर्ट सेटिस्फाइड है कि अर्जेंसी का मैटर था। क्या किसी भी पब्लिक सर्वेंट को अरेस्ट किया जा सकता है ड्यूरिंग द पेंडेंसी ऑफ प्रोसीडिंग? द आंसर इज नो। If the matter is related to the public servant while discharging his official duty, you cannot arrest a person that is a public servant and ना उसको कोर्ट में आने के लिए आप बहुत ज्यादा दबाव रखते हो। ऐसी डिक्रीज का एग्जीक्यूशन कब होगा? तो जजमेंट आने के बाद 3 महीने तक एग्जीक्यूशन नहीं होता है, 3 महीने के बाद ही एग्जीक्यूशन की कार्रवाई शुरू होती है। तो ये कुछ एक एरिया जो सेक्शन नंबर 82 तक था। इट इज वेरी वेरी इंपॉर्टेंट विद रिस्पेक्ट टू यू पीपल दैट ओके कहां से सवाल जो है वो आ सकते हैं। अब अगला जो एरिया है सेक्शन नंबर 83 ऑनवर्ड, इसमें कुछ एक जर्नल एमसीक्यूज को लेके अब हमें फोकस करना है। ठीक है, सो लेट अस बिगिन विद दैट हु व्हेन एलियंस में सू। ठीक है, सेक्शन नंबर 83 ऑनवर्ड पहला आपका जो पॉइंट है कि व्हेन एलियंस में सू। ठीक है, एलियंस मींस फॉरेन कंट्री के लोग आपके ऊपर मुकदमा कम कर सकते हैं। तो दो चीजें हैं हमारे पास। ठीक है, दो चीजें हैं। नंबर वन इज अगर तो एलियन एनिमीज है, मतलब उस देश के लोग हैं जिनके साथ आप अच्छे रिलेशन नहीं है। सो एलियन एनिमीज कैन फाइल अ सूट विद परमिशन ऑफ कोर्ट। with permission of court they can sue। ठीक है, they can sue। ये एलियन एनिमीज अगर केस करना चाहे तो कर सकते हैं इफ दे आर रिजाइडिंग इन इंडिया। और अगर एलियन फ्रेंड्स हैं, ठीक है, फॉरेन कंट्री के साथ आपके रिश्ते अच्छे हैं, एलियन फ्रेंड्स हैं, तो इन दैट केस विदाउट परमिशन आल्सो द केस कैन बी फाइल्ड। विदाउट परमिशन केस कैन बी फाइल्ड। ठीक है, तो एक तो ये चीज है। इसके साथ साथ एलियन एनिमीज रिजाइडिंग इन द फॉरेन कंट्री वो हमारे ऊपर केस नहीं कर सकते। ठीक है, एलियन एनिमीज residing in foreign country cannot sue। alien enemies residing in foreign country cannot sue। ठीक है, एलियन फ्रेंड्स कर सकते हैं विदाउट परमिशन, एलियन एनिमीज कर सकते हैं, अगर वो इंडिया के अंदर है तो केस कर सकते हैं, एलियन एनिमीज जो फॉरेन कंट्री के अंदर बैठे हुए वो केस नहीं कर सकते। ठीक है, तो ये एक जनरल चीज है। इसके साथ साथ सेक्शन नंबर 84 व्हेन फॉरेन कोर्ट्स में सू। ठीक है, तो फॉरेन कोर्ट में सू इन अ कॉम्पिटेंट कोर्ट, तो इसको लेके व्हेन फॉरेन स्टेट में सू, तो यहाँ लिखा हुआ है एनी फॉरेन स्टेट में सू प्रोवाइडेड द ऑब्जेक्ट ऑफ द सूट इज टू एनफोर्स प्राइवेट राइट लिस्टेड इन सच रूलर ऑफ द स्टेट। तो अगर किसी रूलर को केस कर रहा है, उसका प्राइवेट राइट लिस्टेड है, देन ही कैन सू इन इंडिया। ठीक है, तो इसमें से बहुत ज्यादा सवाल नहीं आते हैं आपको। आपको जो सवाल आता है वो आएगा सेक्शन नंबर 88 से। सेक्शन 88 दैट इज द इंटरप्रीटर सूट्स क्या है। तो इंटरप्रीटर सूट के साथ हमारा सेक्शन 88 के साथ कौन सा ऑर्डर चलता है? दैट इज ऑर्डर नंबर 35। इंटरप्रीटर सूट किसके बीच है? इट मींस अ सूट व्हिच इज बिटवीन द डिफेंडेंट्स इटसेल्फ, राइवल डिफेंडेंट्स, बिकॉज़ दे आर क्लेमिंग एडवर्स टू दैट ऑफ द अदर डिफेंडेंट। तो प्लेंटिफ का कोई अपना इंटरेस्ट इन्वॉल्व नहीं है। प्लेंटिफ इज हैविंग नो इंटरेस्ट इन द प्रॉपर्टी, rather he is having an interest only in the charges and the cost, and he is ready to pay the and or to deliver the property to the rightful claimant। but interpleader suit किसके बीच में है? between the rival claimants। ठीक है, between the rival claimants। और सेक्शन नंबर 88 इसके लिए चल रहा है। कब इंटरप्लीटर सूट नहीं हो सकता? when interpleader suit cannot be filed। so interpleader suit cannot be filed in the scenario where in the scenario where there is a collusion between the parties, then in that case interpreter suit cannot be filed। Now the next thing is, just give me 1 second, yeah, so the next thing is section number 89 with respect to the alternative dispute resolution। Any landmark judgment which you people are aware with respect to section number 89? Yes, in the comment box, Phenology Legal. Any judgment which you are aware with respect to section number 89? Any landmark judgment? It is AFCON's infrastructure private limited versus Charial Varke construction company. AFCON's private infrastructure private limited versus Charial Varke construction company. So this is the case with respect to section number 89 and order number 10, rule number 1, capital A, capital B, and capital C, which is altogether related with the concept of the alternative dispute resolution. So what kind of options we are having in the ADR? So it is arbitration, conciliation, judicial settlement, and mediation. Arbitration, conciliation, judicial settlement, and mediation. And judicial settlement is to be regulated with reference to lok adalat, etc. वो सारी चीजें साथ में ही चलती हैं. Now we can't go in that much of detail in these classes, but yes, let us have a quick revision of the Bear Act. Section number 90. It is related with the concept of friendly suits. Friendly suits. कभी सवाल आ जाए तो ध्यान रखना. Friendly suits का है. It is section number 90. It is talking about friendly suits where the parties agree in writing that they want an opinion of the court and court shall try and determine the same. So they will be mentioning their case to the court and thereafter the court is going to decide with respect to its opinion. जो भी कोर्ट का ओपिनियन है कोर्ट डिसाइड कर देगा. सेक्शन नंबर 91 पब्लिक न्यूसेंस को लेके है. यहाँ से आपको कंफ्यूज करने वाले सवाल बहुत बार पूछे जाते हैं. सो लेट अस हैव some brief discussion on that. Section number 91. Public nuisance को लेके कौन केस कर सकता है? With respect to section 91, that is public nuisance. So a suit can be instituted by Advocate General. Suit can be instituted by Advocate General, or it may be instituted by two or more persons. It may be instituted by two or more persons, either with the leave of the court, either with the leave of court, and the second situation is even though there is no special damage has been caused to them. There is no special damage has been caused to them. Okay, so two or more persons can file a suit with respect to the public nuisance even if there is no special damage has been caused to them, but they are obtaining the leave of the court. Then in that scenario, they can file a case. On the other end, the Advocate General is always having the competency to file a suit with respect to the public nuisance. Section number 92, public charities. Section 92, related with the concept of public charities. Okay, public charities. Who can file a suit? Who can file a suit? Again, one will be the Advocate General. Advocate General, and the other person is, that is two or more persons, having interest in the trust, and after obtaining the leave of the leave of court. Okay. So with respect to the public charities, who can file a suit? Advocate General can file, and there can be two or more persons, at least two तो हमें चाहिए, two or more persons having interest in the trust, and after obtaining the leave of the court, they can file a suit. What is the purpose? That why you are filing a suit? That is for removing a trustee, for appointing a new trustee, or if you need a direction from the court to remove a trustee or to deliver any possession of the property, etc. So such kind of persons can be removed or appointed. Section 92, subsection 3 deals with the doctrine of separate That is according to the spirit of trust. Cyprus means according to the spirit of trust. So sometimes the terms of the document or the trust deed, etc., is ambiguous. So the court has to see that okay, was the intention of the trustee or beneficiary. So in that case, the doctrine of Cyprus is being followed, and whatever the spirit of the trust is, in that spirit, the interpretation is being given. Next thing is section number 94, relevant section 94, like supplemental proceedings directly associated with the interlocutory orders. What interlocutory orders it is talking about? That issue of warrant and arrest of a person, attachment of a property, granting of temporary injunctions, appointment of receiver, or other interlocutory orders apart from the above four. If you are getting an order from the court with respect to an interlocutory order, but it is without any reason or insufficient grounds the court has ordered also. Then in that scenario, the wrongdoer can be made liable to pay compensation to the other party, but the amount of compensation will not be exceeding 50,000 rupees. कि अगर एक व्यक्ति ने दूसरे को बिना मतलब अरेस्ट करवा लिया, प्रॉपर्टी अटैच करवा दी या इंजंक्शन का ऑर्डर लिया, जो कि उसको पता था कि वो गलत करवा रहा है, तो ऐसे केस में कंपनसेशन का ऑर्डर सेक्शन 95 के अंदर कोर्ट दे सकता है, और जो कि मैक्सिमम 50,000 रुपए तक का कंपनसेशन जो है वो दिलवाया जा सकता है। और इस चीज को लेके कोई भी सेपरेट सूट जो है वो फाइल नहीं किया जा सकता। लिखा है एनी ऑर्डर डिटर्मिनिंग एनी सच एप्लीकेशन शेल बार any suit for compensation in respect of arrest, attachment, or injunction. So these are the basic things that we have to see. Okay, section 95. Now इसके बाद हमारा पार्ट नंबर 7 शुरू हो जाएगा. Part number 7, dealing with the concept of appeals. Okay, so section number 96 onwards, now we will be starting. It is saying that appeal from a original decree. So original decree के against आप appeal कर सकते हैं, provided कहीं पे restriction ना हो. If any decree is passed ex parte, you can file an appeal. If any decree is there with the consent of the parties, then no appeal can be preferred. If any decree is there passed by the court of small causes and the amount is not exceeding 10,000, तो appeal नहीं कर सकते. But if the question of law is involved, then you can definitely find an appeal in that particular case. Appeal from a final decree when no appeal is there against a preliminary decree. So if there is a preliminary decree, you had not challenged that particular decision of the court and the court passes the final decree, then after the passing of the final decree, you cannot challenge before the court the point raised in the preliminary decree. Your point decided in the preliminary decree. Thereafter, section number 98 dealing with the point that okay, if the judgment is passed by majority of the judges, so majority decision is going to be prevailed. ठीक है, assenting जो judgment है, जो majority होगा उसी को हम मानेंगे. Thereafter, section number 99, that once the decree is passed, it is not going to be reversed, modified, or substantially varied or remanded in appeal only on the grounds of misjoinder, non-joinder, or of parties or of causes of action, or any other defect of irregularity not affecting the merits of the case or jurisdiction of the court. तो आपने अगर कोई भी डिग्री पास किया है, उस डिग्री को एपीलेट या रिविजनल कोर्ट में चैलेंज किया जाता है, तो डिग्री रिवर्स नहीं होगी केवल मात्र से कि पार्टीज का नॉन ज्वाइंटर था या मिसज्वाइंटर था या कॉज ऑफ एक्शन का मिसज्वाइंटर या नॉन ज्वाइंटर है. लेकिन अगर मेरिट्स ऑफ द केस डिफीट हुए तो कोर्ट डेफिनेटली डिग्री को रिवर्स कर सकता है. लेकिन इस धारा में लिखी गई कोई भी बात नॉन ज्वाइंटर ऑफ द नेसेसरी पार्टी पे अप्लाई नहीं होती है. तो अगर नॉन ज्वाइंटर ऑफ द नेसेसरी पार्टी था और फिर भी कोर्ट ने डिसीजन दिया, तो ऐसी डिसीजन को कोर्ट में हमेशा ही चैलेंज किया जा सकता है. Thereafter, section number 100, सेकेंड अपील आपका कब जा सकता है? तो सेकेंड अपील बेसिकली हाई कोर्ट में ही जाएगा जनरली, एंड सेकेंड अपील हमेशा ही सब्सटेंशियल क्वेश्चन ऑफ लॉ पे जाता है. लेकिन एक चीज बहुत इंपॉर्टेंट है कि मान लीजिए कोर्ट ने क्वेश्चन फॉर्मुलेट किया, उसमें अपील पार्टीज की हम सुन रहे हैं, लेकिन उस अपील को सुनते सुनते अगर कोई और भी क्वेश्चन ऑफ लॉ बीच में हमें लगता है, तो हम उस पर भी सुनवाई कर सकते हैं. डजंट मैटर कि ऐसा क्वेश्चन फॉर्मुलेट नहीं हुआ था. सेक्शन नंबर 100 कैपिटल ए कि अगर सिविल केसेस में सीपीसी के अंदर एक कोर्ट के सिंगल जज ने एक जजमेंट दिया है, तो उसके बाद नो फर्दर अपील शैल लाई फ्रॉम द जजमेंट ऑफ अ सिंगल जज. ये बहुत बार पूछा भी जाता है 100 कैपिटल ए के अंदर कि क्या सीपीसी के अंदर अगर किसी जज साहब ने सिंगल जज ने जजमेंट दिया है तो क्या अपील जाएगा? का आंसर इज नो. नेक्स्ट वन इज सेकेंड अपील ऑन नो अदर ग्राउंड्स. तो सब्सटेंशियल क्वेश्चन को छोड़ के और किसी पॉइंट पे आपका सेकेंड अपील नहीं जा सकता. अगर मनी डिक्री का केस है, रिकवरी ऑफ मनी का केस है, तो ₹25,000 से अगर कम का केस है तो सेकंड अपील नहीं जा सकता है। सेक्शन नंबर 104 अपीलेबल ऑर्डर्स के लिए बनाया गया है कि कौन से ऑर्डर्स अपीलेबल हैं। सेक्शन नंबर 104 हमारा ऑर्डर नंबर 43 के साथ चलाया जाता है। ठीक है, तो ये जो ऑर्डर्स यहाँ पे लिखे हैं, ऑर्डर नंबर 35 कैपिटल ए के अंदर अगर ऑर्डर पास हुआ है सेक्शन 35 कैपिटल ए के अंदर, तो आप अपील कर सकते हो। मतलब कि if there is a compensation for false or vexatious claims etc. 91 92 के अंदर अगर कोर्ट ने कोई ऑर्डर पास किया है या 95 के अंदर ऑर्डर पास किया तो उसके अगेंस्ट हम अपील कर सकते हैं, बाकी ऑर्डर्स के अगेंस्ट अपील नहीं कर सकते। इसीलिए कहा गया है दैट नो अपील शैल लाई फ्रॉम एनी ऑर्डर पास इन अपील अंडर दिस सेक्शन। तो बाकी केसेस में आप ऑर्डर्स के अगेंस्ट अपील नहीं कर सकते, सिर्फ वही ऑर्डर जो अपीलेबल माने गए हैं उनके अगेंस्ट अपील दिया जा सकता है। द ऑर्डर्स व्हिच आर अपीलेबल ओनली देन यू कैन फाइल एन अपील, अदरवाइज you cannot file an appeal against all the orders. इसके साथ साथ section number 107 talks about the powers of the appellate court. So what kind of powers the appellate court is having? That is to determine the case finally, to remand the case, to frame the issues and refer them for retrial, and to take the additional evidences. Order number 41, rule number 23, 23 capital A, 24, 25, 26 and 28. ये सारे provisions 27 sir, 27, and these all provisions of order number 41 are dealing with the point that what are the powers of the appellate court. So you have to co-join these order number 41 and section number 107 altogether. After that, section number 113, that is a reference to the High Court. Like if any question is there before the trial court and they want to seek an opinion from the High Court, they can make a reference of the matter to the High Court. Revision always there to the High Court only. It can be only filed before the High Court in the civil matters. Revision can be filed only when there is a jurisdictional error. So if the court has exercised something which is not vested in it, the court has exercised its jurisdiction which is not vested in it, or the court has failed to exercise its jurisdiction, or the court has done something which is illegal or irregular, then in that case you can file a revision before the High Court. Once the revision is there, it does not mean that the trial court will stay the proceedings unless and until the revisional court has directed the trial court to do so. ठीक है, तो केवल मात्र रिवीजन फाइल हो जाने से केस ट्रायल कोर्ट में रुक नहीं जाएगा अनलेस एंड अनटिल हाई कोर्ट ने ऐसा डायरेक्शन दिया। ये चीजें आपको ध्यान में रखनी है। इसके बाद आपका जो रेलेवेंट एरिया है कि हमारे ऑर्डर्स में क्या कोई बदलाव हमारी हाई कोर्ट्स कर सकती हैं, तो डेफिनेटली कर सकती हैं। सेक्शन नंबर 122 हमारी हाई कोर्ट्स को एम्पावर करता है कि वो टाइम टू टाइम जो भी रूल्स हैं, जो प्रोसीजर का एरिया है उसमें चेंजेस अगर करने हैं तो कर सकते हैं। तो जो प्रोसेस है वो इस तरह से that sections area can be amended only by the parliament or state legislature। जो हमारे सेक्शंस हैं उनमें अगर कोई बदलाव या कोई अमेंडमेंट करना है तो ओनली पार्लियामेंट और स्टेट लेजिस्लेचर कैन डू। लेकिन जो हमारे ऑर्डर्स और रूल्स हैं उसमें अगर कोई बदलाव करना है तो लेजिस्लेचर के साथ साथ हमारी हाई कोर्ट भी वो काम कर सकती हैं। तो इसका आपको थोड़ा सा खास ध्यान रखना पड़ता है। नाउ कमिंग टू द लास्ट एरिया ऑफ डिस्कशन, दैट इज पार्ट नंबर 11 कि किस किस व्यक्ति को कोर्ट में आने से एग्जाम्पशन मिला हुआ है। तो सेक्शन 132 कहता है कि द वुमेन्स दोज हु आर because of their customs or manners of the country they are not supposed to come outside। so ऐसी महिलाओं को पर्सनल अपीयरेंस के लिए कोर्ट में नहीं बुलाया जाएगा, ना ऐसी महिलाओं को अरेस्ट किया जाएगा, बिकॉज पहले भी आपने देखा वहां पे एग्जम्पशन मिला हुआ है। सेक्शन 133 प्रेसिडेंट, वाइस प्रेसिडेंट, स्पीकर ऑफ द हाउस ऑफ पीपल मतलब लोकसभा, मिनिस्टर्स ऑफ द यूनियन, जजेस ऑफ द सुप्रीम कोर्ट, गवर्नर, स्पीकर ऑफ लेजिस्लेटिव असेंबली, एमएलए जो आपके होते हैं, इन सारे लोगों को स्पीकर ऑफ द चेयरमैन ऑफ द लेजिस्लेटिव असेंबली, मिनिस्टर्स ऑफ द स्टेट एटसेट्रा, इन सभी लोगों को आप जो है अरेस्ट नहीं करोगे, ना इनको कोर्ट में आने की आवश्यकता है। ठीक है, तो ये एग्जाम्पशंस हैं 133 134 के अंदर। इसके बाद आपके लिए सेक्शन नंबर 137 को आप मार्क कर लेना कि लैंग्वेज ऑफ द सबऑर्डिनेट कोर्ट्स क्या रहती है। सो लैंग्वेज ऑफ द सबऑर्डिनेट कोर्ट्स आर बेसिकली that language of the court subordinate to the high court shall continue to be the language of the subordinate court। तो जो भी हाई कोर्ट का लैंग्वेज है वही लैंग्वेज सबऑर्डिनेट कोर्ट का होगा, लेकिन स्टेट गवर्नमेंट अदरवाइज डायरेक्शंस दे सकता है। तो स्टेट गवर्नमेंट के ऊपर होता है कि वो अपनी सबऑर्डिनेट कोर्ट्स की कौन सी लैंग्वेज रखना चाहता है। सेक्शन 141 मिसलेनियस प्रोसीडिंग्स की बात है 142 जो भी ऑर्डर या नोटिस जाएंगे वो राइटिंग में जाएंगे। 143 पोस्टेज की बात करता है। 144 रेस्टिट्यूशन का कॉन्सेप्ट बताता है कि एक बार अगर एक डिग्री पास हो चुकी है, उस डिग्री को अपील एग्जीक्यूट करवा दिया गया, लेकिन उस जजमेंट के अगेंस्ट अपील भी चल रहा था और एपीलेट कोर्ट ने डिग्री को रिवर्स कर दिया। Again, I am repeating that there is a decree which is being executed by the court, but against that decree, the appeal was already pending, and the appellate court has reversed the decree. So, in that scenario, you have to go for the concept of restitution because आपको decree की execution को reverse करना होता है. Section 145 enforcement of the liabilities of the surety की बात कर रहे हैं. लाइक बहुत बार ऐसे केसेस होते हैं जब डिक्री की एग्जीक्यूशन के लिए कोई व्यक्ति अपनी श्योरिटी बन जाता है श्योरिटी, तो श्योरिटी के अगेंस्ट भी जो है डिक्रीज की एग्जीक्यूशन करवाई जा सकती है। सेक्शन 146 लीगल रिप्रेजेंटेटिव्स के अगेंस्ट हम प्रोसीड कर सकते हैं, ये इसकी बात कर रहे हैं। 147 माइनर्स के केसेस में अप्लाई होता है कि अ पर्सन हु इज अंडर अ डिसेबिलिटी, तो उसके बिहाफ पे जो भी व्यक्ति आ रहा है माना जाता है कि वो व्यक्ति कैपेबल है कोर्ट में केस को कंटेस्ट करने के लिए। सो कंसेंट और एग्रीमेंट बाय द पर्सन अंडर डिसेबिलिटी, ये सेक्शन 147 है। 148 इनलार्जमेंट ऑफ टाइम के लिए है, दैट इफ any time is there fixed by the court to do something and that enlargement is to be done of that time, then maximum time period can be enlarged in 30 days. Section 148 कैपिटल ए कैविएट की बात करता है, कैविएट मैक्सिमम 90 डेज के लिए आपका जो है ये वैलिड रहेगा। 149 deficiency of the court fees, तो किसी भी स्टेज पे at any stage of the proceeding if there is a deficiency in the court fees, you can deposit the court fees in the court and it will be related from the original date when the suit was filed. Section 150 transfer of the business की बात कर रहा है, that if any superior court is there, it has the competency to transfer its business to some other courts also. Section 151 deals with the powers of inherent powers of the court. तो 148 से लेके 151 153 तक सारी पावर्स इनहेरेंट है, लेकिन सेक्शन 151 एक एक्सप्रेस प्रोविजन है that if anything which is not there in the express provision, then the court has the competency to invoke its inherent powers. 152 क्लेरिकल है, अर्थमेटिकल मिस्टेक्स को अगर ठीक करना है then the court can do it on its own motion or on the application of the parties. Section 153 जनरल पावर ऑफ अमेंडमेंट की बात करता है। Basically, during the proceedings, a lot of flaws can be there, the irregularities can be there, and if those irregularities are to be rectified, the court has the liberty to direct the parties to make the amendments, etc. 153 capital A, whenever the appeal, etc., is summarily dismissed, then what the process will be there. So it is the power of the court to amend any decree or order where the appeal is summarily dismissed. So that is the point. 153 capital B deals with the point that whenever the trial is to be conducted in a court, the court shall be the open court. ठीक है, तो ये आपके sections का एरिया था. All this is important which we have referred in the sections which I had referred over here. इनको एग्जाम के लिए आपने अच्छे से पढ़ के जाना है. बाकी the rest of the area related with the point of orders that we'll be discussing in the tomorrow session. Thank you so much. और जितने भी judgments in the initial areas like section 9, 10 and 11 I had discussed with you people, उन सारी judgments का ध्यान रखना है, खासकर डिक्री, deemed decree, इन areas में से सवाल काफी बार आते हैं. Have your command on the Bear Act cover to cover whatever is written in the operative area in the margin heading. Everything is important. Everything is important. So this is all for the today's session. Now in the next session we will be discussing the orders and important areas with respect to the orders of CPC. Thank you so much. We will be discussing the next area in the tomorrow session. Thank you so much.